Apna Course. Get smart, get ahead.
Hello, welcome to session 4 of this course on HIPAA. We have in the previous sessions discussed about the evolution of HIPAA as a legislation and also the definitions of covered entities and why HIPAA is relevant for companies in India. In today's session, we will discuss the civil penalties which are imposed under HIPAA for non-compliance of various regulations. In fact, in order to really understand and appreciate why companies both in USA and in India show so much of concern for HIPAA compliance, we need to recognize the penal provisions of HIPAA. Both HIPAA and more so the High-Tech Act envisage very strict penalties for non-compliance. The penalties could be both civil as well as criminal. Criminal penalties are enforced through the Department of HHS, OCR as well as FTC, that is the Federal Trade Commission. FTC normally comes into being when it is a non-covered entity which has breached certain provisions of health care privacy, but otherwise most of the time the HHS will determine the penalties to be paid. Penalties are often too huge in the sense that one single penalty can actually be crippling, at least in the Indian context. We will see some examples subsequently why we say that no company, particularly in India, can afford to make even one slip up, because we will not be able to pay the compensation which may be required to be paid under HIPAA by the US covered entity, which may get transferred because of the back-to-back indemnity which we might have signed. Basically, HIPAA has three important expectations for compliance. One is the adoption of standards for transactions. Second is protection of privacy. Third is implementation of security standards. Penalty for not adopting standards in transactions could mean that the particular transaction which is reported, which may be a claim or whatever it is, may be rejected for insurance, which means that the healthcare provider who has rendered certain service will not get paid for his work. Penalty for violating privacy or security rule is more in the form of civil penalties and occasionally along with the criminal penalties. So this is generally the aspects which invite penalties under HIPAA. Now, under the old 1996 version of HIPAA, which was in operation until, let us say, 2009, if there was non-compliance of a privacy rule requirement, the Department of Health and Human Services could impose a civil money penalty on the covered entity to the extent of $100 per failure. Of course, when we say per failure, in most of the cases, it is not a single failure which gets accounted. For example, if a certain data is lost, normally the data is of hundreds of patients. So there could be, the penalty will be $100 multiplied by the number of data losses or something of that nature. And HIPAA said that for a particular type of non-compliance, the total penalty in one calendar year is subject to a maximum of $25,000. If there was two or more different types of violations, then it could be $25,000 multiplied by the different types, 2 or 3 different types of violations. Otherwise, the maximum penalty was $25,000 per annum, subject to $100 per failure. This was the old penalty under HIPAA.
Apna Course. Get smart, get ahead.